I'll wait for him to come inside. Okay. Is President McCall gonna be here too?
She is.
Oh, there she is.
Yeah. Thank you.
Okay.
No podium. No podium.
No podium?
Yeah, he's just talking.
I thought they wanted the podium.
No, Darlene just said he's not using
Yeah,
it.
he's not using that, but he wants
She
to
said
speak from the
she was
podium.
like, turn off the podium. I don't know.
Cause she came and she was like, he's
Turn
speaking
this
from.
off?
It's off. No, cause she just told me he's speaking from the podium.
Oh, I thought he said he was gonna sit there.
I don't know. Okay. Okay.
So we don't.
Okay. 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 Yeah. Okay.
To the
Good evening. Welcome, friends. So my name is John Rudisil. I am up here today because I am, in addition to being professor of philosophy here at the college, chair of the pre-law advising program, and it's in that latter capacity that I have the sort of distinct pleasure to make arrangements to bring to our campus the Bell Distinguished Lecturer in Law. We're here tonight to listen to and engage with the 2025 Constitution Day Bell Distinguished Lecturer in Law. It is, or was yesterday, Constitution today. This lecture, this endowed lecture, if not the premier endowed lecture at the college, is at least one of the very best and most prestigious of our annual lectures, and this year is no exception, you'll find. This lectureship in law was endowed in 1999 by Jenny M. Bell and her husband, the late Samuel H. Bell, who graduated in 1947 from the College of Wooster and eventually served with distinction as federal judge of the United States District Court for the Northern District of Ohio. The purpose of this lectureship, and this was stated when it was endowed, is to engage students, faculty, members of the legal profession, and members of the broader community in a legal issue that has broad implications for society. The vision for this lectureship has always been to bring the best minds of the legal profession to Wooster students and the local community, and this vision is certainly being realized this evening. The lectureship also joins together both the Bells' long-held affection for the law and their faith in the values derived from a liberal arts education. This year's Bell Distinguished Lecturer in Law is Columbia University Law School Dwight Professor of Law, Jamal Greene. Professor Greene is a leading constitutional law expert whose scholarship focuses on the structure of legal and constitutional argument. At Columbia, he teaches constitutional law, comparative constitutional law, the law of the political process, First Amendment, and federal courts, among others. He is the author of the 2021 book, How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart, and I've been reading this book and I recommend it to you fully. He's also the author of numerous law review articles that have been published in, among other places, the Columbia and Harvard Law Reviews. He has served recently as, and bear with me, even though this is a partial list, it's long, a Deputy Assistant Attorney General in the Office of Legal Counsel in the U.S. Department of Justice, a Senior Visiting Scholar at the Knight First Amendment Institute at Columbia University, where he commissioned and oversaw new scholarly research relating to free speech and new communication platforms, Visiting Professor at Harvard Law School, Columbia Law's Vice Dean for Intellectual Life, a sought-after media commentator on the Supreme Court and on constitutional law with contributions to, among others, the New York Times, Slate, New York Daily News, and the Los Angeles Times, aide to then Senator Kamala Harris during the Senate confirmation hearings of Justice Brett Kavanaugh, law clerk to Judge Guido Calabresi on the Second U.S. Circuit Court of Appeals and Justice John Paul Stevens on the U.S. Supreme Court. And if all of this does not certify Professor Greene as extraordinarily impressive and cool, he was also once a baseball reporter for Sports Illustrated. We are both fortunate and grateful to have Professor Greene here with us tonight. Please join me in welcoming him kindly to Wooster.
Wow, thank you for that wonderful introduction, and thank you all for having me here. This is my first time in Wooster, first time at Wooster, and it's great to be here. I want to talk about free speech. We have in the last, I think, several decades witnessed what you might call a series of panics over freedom of expression on college and university campuses. And since I am both a constitutional lawyer and someone who works on a university campus, this is obviously something that is up my alley. I think that since I'm now giving a speech on a college campus, it's up your alley too at this point. And I have to say, in light of the horrific murder of Charlie Kirk last week during a talk on a college campus, the issue of free expression on college campuses is sadly up the whole nation's alley right now. So I'm going to mention what I think have been a series of, I'll say panics. It's maybe a little bit more pejorative than I intend, but a series of panics over free expression in the last several decades. And I'll say what I mean specifically, but I'll preview that I have different and often complex feelings about each of these, again, what I'll call panics over free expression. And what I want to try to convey is a little bit about why I see each of them as quite distinct and calling for very different kinds of responses from governments and from critics within civil society. And in doing so, I'm trying to hopefully help us all to better understand the role that context plays and has to play anytime we talk about alleged interferences with free expression. So let me first say exactly what I'm referring to and what I mean when I say panics over free expression. At universities, at least some of these will be familiar to all of you, some of them maybe less so. So first, in the 1980s and 1990s, several universities around the country adopted codes of conduct for students that forbid certain forms of race and sex-based harassment. These codes of conduct were deemed to be so-called speech codes and came in for heavy criticism, I think both from people on the political right and from a number of people on what you might call the kind of left liberal political left. Some of these codes of conduct were invalidated by courts. The codes of conduct at the University of Michigan, at the University of Wisconsin, both public universities, but also the code of conduct at Stanford University was invalidated by a state court in California for violating the California Constitution. So that's the first kind of, what I'll call the first kind of panic. We'll call it speech codes. So I'll say a little bit in a bit about how I feel about that label. Second, in the early 2000s and 2010s, a concern arose, and this will be very familiar to all of you, over the lack of ideological diversity among students and faculty, and a related concern over what is sometimes called cancel culture, in which people with disfavored ideas were disallowed on campus or shouted down or socially censored in a variety of settings. So we'll call that the second panic, is panic over cancel culture. So first is speech codes, second is cancel culture. Third, more recently, there have been, as you're all aware, serious concerns over campus protests in relation, especially in relation to the war in Gaza, and whether and to what degree protesters or agitators have engaged in anti-Semitism or have made Jewish students, faculty, staff, feel harassed or threatened or unwelcome on campus. So we'll call that the third panic, is sort of anti-Semitism, and especially in relation to protests around Gaza. And then finally, in the last few months, the Trump administration has paused or rescinded research funding to universities for studying topics that the administration disapproves or because of alleged anti-Semitism on campus, often in relation to the protests. In the case of Harvard, the administration went further than that and has gone further than that and has threatened the university's tax-exempt status and has also attempted to prevent it from enrolling international students. So that's the fourth. So you've got speech codes, number one, sort of cancel culture, number two, anti-Semitism and its relationship to protest, number three, and then the administrative response, number four. So let's begin first, and I want to kind of make a series of observations about each of these kind of panic and hope that we can at least think slightly differently about them than we did before. So speech codes, so-called speech codes, and I say so-called because I think calling these kinds of policies speech codes implies that their primary function and their primary operation is to contain free expression. Imagine instead if we referred to them as harassment codes, which doesn't have quite the same ring to it as speech codes, but would emphasize, I think, that at least in the intention of many of these policies, the restrictions on speech were incidental side effects of restrictions on abuses of students. So I think for context in trying to understand the so-called speech code movement of the 1980s and 1990s, I think it's helpful to examine not just specific speech codes and what they said, but also to say a little bit about why they were put in place. So between 1986 and 1990, more than 250 colleges and universities reported openly racist incidents on their campuses, from sort of swastikas being left places, nooses being left places, death threats, physical violence. At the University of Michigan, which I'm going to say a little bit more about in a moment, in January of 1987, someone distributed a flyer in a residence hall in which black students had been meeting, and the flyer said, declared so-called open season on saucer lips, porch monkeys, and jigaboos. A few days later, same campus, University of Michigan, the radio station aired a program that included a series of racist jokes. I thought about whether I should say some of the jokes so you know exactly how racist we're talking about here, but I'm actually going to refrain from doing that and just say super racist jokes, right? Not the kind of thing that you would ever see other than in the darkest corners of the internet, let's say. Demonstrators protested at the radio station, and in response to that, they were greeted with a KKK outfit being hung from a dorm window as they returned from their protest. In 1989, at the University of Mississippi, one of the fraternities decided that the way in which they were going to handle pledges was to paint the words KKK and the words "We hate niggers" on the naked bodies of two of their pledges and send them to the local historically black college. At Emory University in 1990, a black female student who was assigned to a dorm room with a roommate, she showed up and her teddy bear was slashed, her clothing was doused in bleach, nigger hang was written in lipstick on the wall, and die nigger die was written in nail polish on the floor of her room. I actually just yesterday spoke to a colleague, it just happened to be, it was a casual conversation that just sort of came up in conversation, a colleague of mine who went to college in the 1980s during this period. She's an African-American woman. And she said, you know, she put up a lot of flyers in college and advertising black student organization events, for example. And she said almost every single time those flyers were defaced with the N-word, with swastikas, and with other racist symbols. And she said this happened so often that it didn't even occur to her at the time as a college student to report it to anyone. She just said, this is what happens. This is just life as a black woman on a university campus in the 1980s. Those incidents arose as a fairly direct consequence of the racial integration of college campuses in the 1970s and 1980s. There were more black and brown people on campus, and many people, sometimes quite intentionally, sometimes unintentionally, were conveying in the starkest of terms that these people were not welcome on university campus. So when we talk about speech codes, this is what they were responding to, those kinds of incidents. And so the University of Michigan, which is one of the places I just mentioned where these incidents happen, put in place a code of conduct that said that stigmatization, harassment, and intimidation based on race, religion, sex, and sexual orientation would be violations of the Code of Conduct. A student sued the University of Michigan in federal court, and the student won to strike down this Code of Conduct. And the court said that because the University of Michigan is a public institution, it could not say that certain speech was forbidden on the basis of the message that that speech intended to convey. A similar policy was struck down at the University of Wisconsin, which put in place its own policy after a fraternity on campus hosted a slave auction in which pledges in blackface performed minstrel rituals. At Wisconsin, the students who were disciplined under its code of conduct, under this harassment code, I'll now call it, they were not kicked out of school, they were not suspended. They were typically, and in almost all instances of discipline under this code of conduct, it was for racial or sex-based slurs spoken to roommates and classmates. And the typical response from the university was sensitivity training, and in some cases substance abuse training, because this often happened when people were under the influence of drugs or alcohol. And so that was the policy, but a federal court struck down that policy as well, says you can't have it at all, for similar grounds as the Michigan policy. A public university is not allowed to discriminate on the basis of the message that speech is intending to convey. Now, I think these court decisions are quite wrong, and I want to spend a little bit of time on exactly why I think they're quite wrong. But to start, I think it's important to say that freedom of expression is obviously vitally important in a democracy, right? Free expression is necessary to create a democratic culture. It's necessary to enable us to formulate and develop and defend our ideas and to develop our sense of ourselves in the world. It's necessary for us to develop our personalities, to become autonomous individuals. It's necessary to promote an ethos of tolerance of other people who live within the world, even people we fundamentally and profoundly disagree with. I think free speech is necessary for us to thrive, and it's necessary for us to live together peaceably as a society. You don't need to reject any of that to also believe that a university, including a public university, should be able to enact a student code of conduct that forbids students from racially and sexually harassing their classmates with slurs. I'm going to burrow in a little bit here because this is a very important point, and I think sometimes some aspects of it are easy to overlook. Freedom of speech is a very broad category of right. Because it's such a broad category, speech is everywhere, freedom of speech is not an absolute right. Sometimes people say it is, but no one actually believes that freedom of speech is an absolute right. And if you think otherwise, just ask yourself whether you think the federal government could, let's say, fire a TSA agent for commenting on the breast size of every woman who passed by, or whether an air traffic controller who decided to intentionally give wrong information about the location of planes could be criminally prosecuted for doing that. Speech is how we communicate. And so, of course, there are instances in which speech can be constrained or regulated by the government. And again, once you think about it for a few minutes or a few seconds, no one really disagrees with that. Once we agree that speech, that some speech can be interfered with or punished, the question for a constitutional lawyer becomes, well, how do you make sense of freedom of speech? How do we distinguish the speech that we can interfere with, that the government can interfere with, from the speech that it can't? It's not going to be sufficient just to distinguish more harmful from less harmful speech. There's lots of fully constitutionally protected speech that is much more harmful than crude comments from a TSA agent, for example. Vaccine misinformation, for example, can be incredibly harmful, but it's fully constitutionally protected. We don't protect freedom of speech because speech is harmless. We protect freedom of speech despite the ability of speech to be harmful. I think Oliver Wendell Holmes in 1925 maybe said it best when he said, every idea is an incitement. At least it can be. So if harm is not the line that we draw between speech that the First Amendment fully protects and speech that it doesn't, what is the line between protected and unprotected speech? The difficulty of this puzzle is the reason why, if you go to a law school, a course on freedom of speech lasts a full semester, sometimes a full year, and that's not enough time, in fact, because working out exactly what you do with our basic mode of communication and how and when it can be regulated is really hard. So what happens at the Supreme Court of the United States is that over time it has developed a bunch of somewhat abstract categories to determine the nature of certain kinds of speech. And sometimes speech can be regulated and sometimes it can't. And so to answer a First Amendment question, the Supreme Court asks questions like, is the regulation on the basis of the viewpoint of the speech? Is the regulation on the basis of the content of the speech? Is the regulation on the basis of the speaker's identity? Those kinds of discriminations are generally not allowed in U.S. constitutional law. Is it a time, place, and manner restriction? Is the government regulating so-called expressive conduct? Is it commercial speech? Is it obscene speech? Is it a traditional public forum like a park? Or is it a limited public forum like a debate stage? Or is it a non-public forum like the post office? Is it images of child sexual images? Lots and lots of categories. And you learn to navigate these categories if you go to law school and you take a course in First Amendment law. And it can be really dizzying to try to sort out all these different distinctions, but there's actually, I think, another distinction that doesn't show up much in First Amendment law, but I think should show up in First Amendment law. And that's the distinction between different institutional regulators of freedom of expression. The question we don't tend to ask in U.S. First Amendment law is, who is the government? And what are they trying to do to the speaker? So when it comes to thinking about discrimination on the basis of viewpoint, which the Supreme Court will say again and again, and has said again and again, is something the government never gets to do, almost never gets to do, should we put the police officer to the same test as we put the college administrator at a public school? Another way of putting this is that free speech questions might very well look different at different kinds of institutions. Wooster College is a private institution, but it's a private institution that has much more in common with Ohio State, a public institution, than it has in common with the state police. And yet, the First Amendment law treats Wooster College as radically different from Ohio State. In fact, the First Amendment doesn't bind Wooster College in any way, and it binds Ohio State rather radically. It treats Ohio State in the way it treats the police, right? So when we think about how speech can permissibly be regulated, what I'm trying to suggest is that some of the categories that we create, some of the ways in which we construct groups in First Amendment law should be according to institutional settings and not just according to what kind of speech is being regulated. It is coherent to say that a school can protect its minority students from slurs by requiring sensitivity training or placing a student in substance abuse rehab. But at the same time, the same speaker can't be arrested for saying the very same thing. That should be obvious, I think, but it's not how First Amendment law currently works. Now, I happen to be someone who favors, I think, a relatively light touch when it comes to schools and how public schools and private schools should respond to offensive speech by their students. I think schools should treat student speech as much as possible as a pedagogical moment and treat it in an educational spirit. Living in a pluralistic society means being surrounded by people who hold views that one disagrees with. Democratic politics requires engagement with such people to negotiate compromises, to develop empathy for them as fellow human beings and fellow community members. University campuses, I do think, can often be dominated by large majorities who engage in various forms of groupthink and have very similar politics, and it's important to challenge those views. It's also, I think, the case that for people who want to be intentionally provocative, whose objective is often to generate publicity, the greatest favor you can do to them is to try to regulate their speech. That's what they want you to do. Right? So there are lots of reasons to tolerate even extremely offensive speech, and there's lots of reasons to tolerate offensive speech on a college campus. I can say all of that, and at the same time say that schools, administrators, faculty should have the discretion, and in fact need the discretion, to say that not all viewpoints are equally tolerated within an educational community. The school's role is not just to license experimentation, but it is also to emphasize the role of persuasion in democratic discourse. It's to emphasize the need for us to engage with each other civilly and not just to engage at all. And there are many different ways of doing that. Which brings me to the second panic, which is about cancel culture and speakers on campus, not just students themselves, but people who are invited to campus. I'll give just a quick example. In 2017, a student, he actually wasn't a student enrolled at the university, but that's an interesting detail. A student invited Richard Spencer to give a speech at Auburn University. Richard Spencer is a white nationalist, he's a Nazi sympathizer. And the university cited security concerns and said he couldn't come and speak on the campus. Auburn University is a public university. And he went to court, and he won. The judge noted, as the Michigan and Wisconsin judges had noted, that, quote, discrimination on the basis of message content cannot be tolerated, and, quote, listeners' reaction to speech is not a content-neutral basis for regulation. The opinion did not make any reference to the fact that Auburn was a university. The reasoning assumed that the school was just like any other state agency or public official, could not discriminate on the basis of the content of the message. And on that view, Auburn would have to permit someone on campus giving a speech promoting racial antagonism if they would also allow on campus someone who's promoting racial tolerance, right? So you can't discriminate between those different viewpoints. That's a fairly orthodox, straightforward application of First Amendment law. So the judge in that case did not do anything that is necessarily inconsistent with how the Supreme Court has understood First Amendment law for a long time. And I agree with the basic sentiment that if some public institutions allow people to speak when they are engaged in acts of racial antagonism, racial tolerance, they have to allow racial antagonism as well. But I agree with that when it comes to whether Richard Spencer should be arrested for his speech, or whether he should be allowed to give that speech in a different place, such as a park, or whether he should be allowed to give that speech if sponsored by a private organization on their own space. I disagree with that sentiment when it comes to a university. Again, because a university is a particular kind of institution, and the law can and should be attentive to that particular institutional context. And to be clear, I don't mean that Auburn should not have permitted Richard Spencer to speak. I don't know what they should have done. I don't know what I would have done in that circumstance. But I do mean to say that the school's administrators and faculty, not a federal judge, should have been the ones making that judgment, which I think is fundamentally a pedagogical and educational judgment, and not a legal judgment. I'm thinking here of some events that actually happened at Columbia a few years ago. I'll talk about other events at Columbia in a moment, but a few years back, also in 2017, sort of the heyday of talking about cancel culture, the Columbia College Republicans held a quote, free speech month. There were a lot of college Republican groups that did free speech week or free speech month at the time, and they invited Tommy Robinson and Mike Cernovich to give talks over the span of a couple of weeks. I don't know if you follow these circles or remember who Tommy Robinson's still in the news, or Mike Cernovich are. Tommy Robinson is best known for being an Islamophobe and a football hooligan. He's English, so soccer hooligan. And he was, at the time, he had been kicked off of every social media platform for engaging in what he referred to as a war on Muslims. Mike Cernovich is the sort of best known promoter of so-called Pizzagate. If you remember what that was, it was a conspiracy theory that various Democratic operatives like Hillary Clinton were engaged in a child sex trafficking ring operating out of a DC pizzeria. And that pizzeria was shot up by someone who believed in this conspiracy theory. Later, so these were the people the college Republicans decided to invite on campus to talk about immigration policy. It was not something they have any expertise on. They didn't invite them to promote the robust exchange of ideas. They invited them because they were provocative. And predictably, they provoked. There were protests, interruptions. Robinson had to stop his speech early. The Black Students Organization called for the college Republicans to lose their university funding. And there were huge security costs. Just everyone just got mad at each other. There was no robust exchange of ideas at all. And I tell that story not to say, well, what should have happened necessarily, but to say, well, imagine if faculty or administrators at Columbia, in advance of this, all this was predictable, in advance of this said, if you want to have someone on campus, you have to persuade us of the pedagogical value of this person being on campus. You have to make a case to us that they're going to contribute in some way to the intellectual life of the school. Shouldn't an educator be able to make that kind of judgment, just as they make that kind of judgment in the classroom, and just as they make that kind of judgment outside the classroom as well? We understand this in the context of university admissions, and we understand this in the context of university hiring, right? And so if someone says, I would like to be admitted to Columbia University, and oh, by the way, my essay says that I'm a racist, if Columbia says, or I won't use Columbia, let's say Ohio State, public school. If they say, actually no, we prefer you not to come here, if that's what you're fundamentally committed to. I mean, the law can change, but no one really thinks that that's an improper judgment to be made by the university. Likewise, if they're doing faculty hiring and someone says, okay, my research agenda is I'm a Holocaust denier and I'm an anti-Semite, but I'm really smart. And the faculty says, we're going to pass on hiring this person to teach our students. Even at a public university, I think we're still not at the point where we think that that's actually problematic. But it's really the same thing from a free speech perspective. It's actually very hard to articulate why a public university is allowed to make that judgment. But we all kind of understand why it's entirely appropriate for them to make that kind of judgment. There's also, I think, when we think about schools making their own judgments about these sort of things and exercising their own discretion, there's a democratic value in that as well, which is to say different schools will have different approaches to how to handle speech on campus that might offend people, that might challenge them in different ways. And in other contexts, we tend to think that, if you have a complex question, having a lot of different institutions have their own approach, much like in the federal system that we have at the level of governance, that's good. You let 1,000 flowers bloom, you see what works and what doesn't work. I think there's no reason not to do that sort of thing in this context as well. Which then brings me to the third panic. And I'll take a quick sip before I continue. Because the next two panics will be very personal to me as a Columbia University professor. So the third is about protest and about anti-Semitism and campus protest, especially in the wake of the October 7th Hamas attack on Israel and Israel's ongoing response to that attack. As I think most people in the audience, maybe all of them know, there have been accusations that in the course of many of these protests, and in other settings as well, Jewish students have been subject to anti-Semitic harassment. Now, there is no doubt that has happened on many campuses, including my own campus, Columbia University. Anti-Semitism against a university's students or against its faculty or against its administrators or staff is a problem in itself that the university has, I think, both a right and a duty to address, for the same reason that it has a right and a duty to address race-based harassment or sex-based harassment on its campus. It has a responsibility to its community members to do that. It's also the case that based on interpretations of Title VI, this is the federal law that conditions federal funding on non-discrimination on the basis of race and color and national origin, on interpretations of that law that I think are quite reasonable interpretations. A school being indifferent, deliberately indifferent, to pervasive anti-Semitism on its campus could constitute a violation of the statute and lead to enforcement action by the federal government. All I've said so far about these issues is, I think, easy enough to agree on. Again, namely that there has been anti-Semitic behavior and actions on campuses that has happened in the context of protests, and on, again, what I think are reasonable understandings of Title VI that can lead to a Title VI violation. Now, virtually everything else that one might say about campus protests in this particular context is contestable, often in ways that are profoundly personal to many Jewish and many Muslim students on campus. For a few different reasons, a university's approach to anti-Semitism in the context of these particular protests is quite complex, in some ways that I think overlap with other forms of discrimination and anti-discrimination policy, and in some ways that don't. So for one thing, there is the relationship between anti-Zionism and anti-Semitism. The International Holocaust Remembrance Alliance has a controversial definition of anti-Semitism that says that it could include, for example, saying that the state of Israel's existence is racist. That could include, quote, applying double standards by requiring of Israel a behavior not expected or demanded of any other democratic nation. Its definition of anti-Semitism could include, quote, drawing comparisons of contemporary Israeli policy to that of Nazis. So under this definition, arguably, referring to Israel's treatment of Gaza as a genocide could be described as anti-Semitism. And allowing faculty to make that kind of accusation, an accusation that the UN Human Rights Council itself recently made, could subject a school to loss of its federal funding under Title VI. Now, needless to say, I think, this kind of speech falls into the heartland of academic freedom, what would ordinarily be protected political expression, whether or not someone believes that it is also anti-Semitic. I'm not suggesting here exactly how anti-Semitism should be defined. I don't have a strong view about that. I am suggesting that if it is defined in a way that equates anti-Zionism or certain criticisms of Israel with anti-Semitism, it greatly complicates the task of steering Title VI and steering any student code of conduct clear of the First Amendment and clear of promoting a culture of free expression of political beliefs. This challenge, I think, reflects a more general challenge with Title VI, namely that comments about race and color and national origin, which are the categories that Title VI applies to, might both offend and also constitute speech on matters of public concern or public discourse that we would ordinarily say is protected by the First Amendment. What I think is a bit different here is the broader geopolitical context. Right? Equating views about Israel's conduct with views about Jews may itself arguably be described as anti-Semitic. There is no easy way out of the challenge that this presents. I'll also say that given the nature of the conflict in Gaza, the availability and structure of protest may well touch a nerve with students and faculty and administrators and staff that winds up being more personal than most campus conflicts. It's pretty hard to say anything interesting about the war in Gaza in any political direction that does not run a serious risk of offending someone, often in ways that feel extremely personal to people. That wasn't the case when it came to protests of apartheid in South Africa in the 1980s. That wasn't the case when it came to protests of the killing of George Floyd more recently. But that is the case with this particular conflict. That kind of powder keg represents an enormous challenge for university governance. It also strikes me as an especially poor candidate for a ham-handed or contextually insensitive government intervention. And yet here we are at the fourth and final panic that I want to say a word or two about. The federal government has claimed that several universities, including Columbia, have not done enough to combat anti-Semitism on their campuses. And for that reason, their federal funding, mostly for scientific and medical research, has been paused. And as many of you know, Columbia reached an agreement with the government to try to restart that funding. Now, the federal government has been cagey about its legal authority to pause appropriated research funds based on claims of anti-Semitism. Now, Title VI, as I mentioned, arguably gives the government the power to do so, but the government's pauses did not follow the explicit requirements of the Title VI statute, and the government is more or less concedes that they didn't follow the procedures that would need to be followed under Title VI. Title VI is intended to promote voluntary compliance, and the only instances I'm aware of in which funding has actually been withdrawn, before this year, has actually been withdrawn under Title VI was during the school segregation era in the 1960s. So apart from Title VI, which again the federal government has not pursued the procedures under Title VI, withdrawing or delaying federal money that has been appropriated by Congress is a usurpation of Congress's power of the purse. There is no general constitutional or statutory authority for the executive branch to just refuse to disperse money that has been appropriated. And more broadly, the administration's approach to universities has been defended by the administration itself, and repeatedly by the administration itself, as a kind of punishment for these universities either being too lefty or for them refusing to cut a deal with the president. Punishing universities for the political beliefs of their faculty or for their decision to litigate against the government is as straightforward a violation of the First Amendment as you're ever going to see. And yet, Columbia cut a deal. As some have said, it bent the knee. Should it have done so? I will confess that among the many disturbing aspects of Columbia's deal with the administration, the fact that Columbia agreed to it at all is actually pretty low on my personal list of grievances about it. First on my list is the lawlessness of the administration itself. Right? I'm not happy about the agreement with the government, But as with any hostage situation, the first person I'm going to blame is always going to be the hostage taker, and not the negotiator, and not the hostage. A university trustee has fiduciary responsibilities that extend beyond faithfulness to their own views about authoritarian threats, how to respond to them, their views about constitutional democracy. I worry deeply about authoritarian threats and about constitutional democracy, but I don't envy the situation the trustees found themselves in. And I think when a university is facing lawless, but nonetheless existential threats from the President of the United States, I'm not at all sure what decision either fiscal responsibility or moral courage most recommends for that university. I do think that we should lift up and support those who are able to resist authoritarians. And in fact, the only time, I'm a Harvard College graduate, the only time I've ever given money to Harvard College was in April of this year. So I think we should lift up and support those who resist authoritarians. I'm less keen to trash those who don't feel as though they are in a position to resist authoritarians. I think it's just too complicated. Now, my second big worry beyond the bare lawlessness of the administration about Columbia's agreement is a bit more inchoate, let's say. As my colleague David Posen has described it, what we are seeing a lot of in the second Trump term is so-called, what David Posen refers to as regulation by deal. So rather than go through a lawmaking process in Congress or going through a rulemaking process in a federal agency, the president prefers to coerce institutions, whether they're media organizations or law firms or universities, to coerce them into entering into bilateral deals with him and his team. Regulation by deal, whatever you think of the substance of the regulation, maybe you like what the president's doing, maybe you don't, in terms of the substance, but regulation by deal is a profoundly disturbing development. It lacks the procedural legitimacy of lawmaking or rulemaking. It frequently lacks any transparency whatsoever. It is produced under coercive conditions. I don't think it's too much to say that it indeed abandons the very premise of collective governance, which is that we, the people, determine the degree of coercive power the government gets to exercise. And the government exercises its power in ways that are general, that are prospective, and that are transparent. The Constitution, one of the only things the Constitution specifically prohibits in the original Constitution before the Bill of Rights is bills of attainder and ex post facto clauses in legislation. Bill of attainder is a law that applies only to a specific individual, and an ex post facto laws criminalize conduct that occurred before the law was passed. Those were prohibitions in the original Constitution because they're so obviously inconsistent with ordinary democratic governance. Lawmaking is not the personal prerogative of the president. It's a public act. It's not a private settling of scores. That's the exact opposite of public law. For each of the panics that I've discussed, so speech codes, canceling of speakers, anti-Semitism on campus, and the administration's ideological coercion, I hope I've said at least one thing that has made you think about them in a way that you had not thought about them before, whether or not you agree. The one constant theme that I think cuts across all of these issues, for me, is a plea for the autonomy of the university to make decisions about the educational environment on campus. Lord knows universities are not perfect, nor is their internal governance always well-structured and responsible. It is not, as with many other institutions. But the judgments required to sort out the line on campus, which is a community, after all, between racial harassment and free expression, or between the value of tolerance and the value of civility, or between allowing offensive speech and allowing political expression. These are educational judgments, and they should be educational judgments and not legal ones. Whatever we think of the performance of universities over the last few years, and we all have opinions about this, people in college towns tend to. Whatever we think of the performance of universities in recent years in educating students, in contributing to the production of knowledge, in producing high-functioning democratic citizens, they have done nothing for which an appropriate response is to convert them into wards of the federal government. Giving universities, including public universities, substantial autonomy to shape, to regulate, to constrain even the modes of expression on their campuses is, I think, or should be, the very embodiment of the First Amendment and not an exception to it. Thank you. So I might stand here for a bit for your questions rather than sit alone in these chairs over here.
Okay. Of each of the scares that you talked about, which would you say has or will be the most detrimental to our society, in your opinion, and what should we be doing to either reverse the effects or prevent this from causing even more damage than it already has?
So of the four things I mentioned, and I'll say, because I think this is important context, I have various problems with the ways in which colleges and universities have responded to all of these things. But the only one that I think is a genuine, ongoing sort of catastrophe is the last, right, which is the government playing the role that it's playing. And part of what I wanted to emphasize, and this is maybe a little bit subtle, is that federal courts are part of the government too. And so when a federal court says you must structure the educational environment on your campus in the following way because we have a particularly absolutist or formalist view of the First Amendment, that too is a form of government coercion that I think is problematic. I don't think it's nearly as problematic as the actions of the administration, which I think have been pretextual, have been in bad faith, and I think really do threaten the very notion of academic freedom. I think we have a tendency, a tendency to feel as though whatever is happening in the moment is forever, and I have a lot of pessimism about the moment that we're in, but I also recognize that we've had pessimistic moments in the past, and I don't know what the world will feel like or look like a year from now or 5 years from now or 10 years from now. I think things can change. I think they may change. But I think we are in a genuinely, if not already there, in a serious threat of a kind of authoritarianism that we have not seen, at least in this century, or the last century, I should say, in the United States, and maybe ever.
Hello. Hi. How can we limit coercion? What should we as citizens do to interact with the government to do that?
How can we limit coercion by the government? Well, I think for the moment we can't. And that's why it's such a dispiriting moment in which we find ourselves. I think the optimistic thing that I can say is that we can participate in civil society. We still can participate in civil society in a wide variety of ways. We can talk to our friends, colleagues, neighbors And I think ideally across political divides as much as possible, recognize our commonality. We can write and communicate with our fellow citizens in that way. We can vote eventually. I do have some worries about what our elections are going to look like because I think that the intentions anyway of at least some people within the administration is to limit voting in a way that will perpetuate their power. And I think that's extremely worrisome. But, you know, I think the term that political scientists use for where we threaten to be is competitive authoritarianism. At least some political scientists use that term, which is to say, yeah, there are still elections, but everyone knows they're kind of rigged and only one side's. There's still civil society. People are able to criticize the government sometimes, but there's always a kind of backstop of it only goes so far. And there's an appearance of normalcy and regularity, but not a reality of that. I don't think we're quite there yet. At least I don't think we can say for sure that we're there. And so for now, you participate in politics in the same way in which you participated in politics your whole life, maybe with more urgency now, because it's important that all of us be engaged.
Hi, I'm right here. I'm wondering how you would deal with, does like the institutional academic freedom begin and stop at the institutional level? How would you weigh professors' academic freedom and the institution's values if they're opposing?
So professors within a university, this is a tricky question. And this is one where I actually have a slightly different set of beliefs than a lot of people who share my politics. I tend to think that, you know, I think we can talk about the law and we can talk about the culture and spirit on a campus, right? So academic freedom I think, is and should be a legal institution. It's something that the Supreme Court itself has recognized as a thing. It hasn't defined its contours very well, but in the key Supreme Court cases involving academic freedom, it recognizes there is a thing called academic freedom. The court is not very, hasn't told us very much about the distinction between the government regulating the academic freedom of an institution versus a public institution regulating the academic freedom of its faculty. I tend to think that as a matter of free speech and free expression culture, it is appropriate for institutions to give a quite wide breadth of academic freedom to their faculty members. As a matter of First Amendment law, I think it would be very hard, I think it will be very hard, to construct a First Amendment law in which faculty members at a public institution have robust First Amendment rights against the institution itself. They're employees of that institution. Institutions are allowed to decide what their mission is, what their values are, and this is a form of government speech, what are the boundaries of what they will teach or what they won't teach. If this seems controversial, sort of think about it at the level of an elementary school, and whether teachers can rebel from what their school districts tell them they're supposed to teach. Again, I think the right spirit for a public institution or an administrator is to allow quite a bit of breadth there. But when we talk about legal coercion, should a public school teacher be able to sue their institution because they couldn't teach in the way they wanted to, but the institution didn't? That gets very difficult to reconcile with ordinary employment law. And so I think that's pretty tricky as a legal matter. But again, the First Amendment doesn't just live within the law. It also lives within the culture of an institution. And so I certainly favor a more open-spirited culture, but it's a little bit trickier when it comes to the law.
All right, so my question is pretty different from that. My question is, what lessons, if any, do you think we could learn from how other countries have approached free speech and academic freedom, especially since you do teach some comparative constitutional law, as Dr. Rudisil pointed out?
So I think there's a short version of this, of an answer to that question, and a longer version. The longer version is sort of read the book that was just put up, which I think is gets much deeper, and there are a number of comparative examples in the book. But the short answer is that most countries in the world, and I think this is something that's not very well understood, even by lawyers in the United States. Most countries in the world tend to think about rights in a quite different way than Americans think about rights. And I think the crudest way that I can, and again, I have a book about it, so there are less crude ways, but the crudest way I could describe it is Americans tend to believe that you have a narrow set of rights, and you hold those rights more or less absolutely. And in most legal systems, most democratic legal systems with enforceable constitutions think people have quite a lot of rights, but those rights are not absolute. And those are going to be a trade-off, right? So once you say that rights are absolute, we live in a society, right? We have people are making claims of rights all over the place. If you say that everyone has an absolute right to everything, they're going to clash with each other, and they do, and you got to figure out what to do with that. And so, again, the American model tends to say, we the court, let's just talk about courts for the moment, we the court are going to decide what are the specific boundaries of the rights that you have, and we're going to protect those robustly. And again, in most other systems, they're less focused on those particular boundaries of how you define the right itself, and they spend a lot of time talking about, well, how limited is this right going to be? You have a right, but so does the rest of society, and so we've got to limit it in some way. The very quick example I'll give is, and I know that you've studied the West German, German and then previously West German Constitutional Court. The example is from West Germany. There's a fairly well-known case in German constitutional law involving a woman who wants to feed pigeons in a public square. It's the so-called pigeon feeding case. And she says, I have a constitutional right to feed the pigeons, but there's this local ordinance that says I'm not allowed to feed the pigeons. You're violating my rights. This is very important to me. And in the US, this would be a very easy case. They would say, you don't have a right to feed pigeons, goodbye. And maybe we're going to sanction your lawyer for bringing this litigation in the first place. In the West German Constitutional Court didn't say she didn't have a right to feed pigeons. In fact, it said she does. But it said, but anytime there's a right, we have to figure out, well, what's the social interests on the other side, and are they being reasonable in the way they're pursuing those social interests? And okay, the ordinance was passed because they're worried about feral pigeons running around like pooping in everyone's cars and everything, and spreading disease, and that's a legitimate thing for a society to worry about. And this is a fairly narrow way of worrying about this, and it's just a minor fine if you feed the pigeon. And so we're going to decide, we're going to make a judgment that actually, yes, you have a right, but you still lose because you live in a society. And so one thing I would urge, and one thing I do urge in the book, is to think more in those kinds of terms, which is we don't need to say that the Constitution itself discriminates deeply between the rights that we have, that you have a right to free speech, and that therefore means I don't have a right to equality or something like that. When rights clash, as they will, as they do, as they inevitably do in a complex, diverse society, there are ways of saying, yeah, you all have the dignity of being rights holders, but our job as an adjudicator is to explain to you what the rights of others might be and how your rights interact with those rights. And so we're going to try to create a culture of rights, but a culture of rights that's also a culture of respect for other people. For a variety of reasons, I think that would have been and still is a better avenue for courts to go down than the way in which we tend to do it, which is to say, no, there's only a small number of rights. We're going to go and consult 18th century dictionaries to figure out what they are, and then once we figure out what they are, they're going to be protected absolutely. I think that that's destructive for a number of reasons.
Hi. This is kind of a double-header question, so bear with me. But in the wake of the death of Charlie Kirk, as you mentioned earlier, and I'm sure you've seen on the media about a bunch of the firings of many different people in different workplaces based on their comments on his death, do you believe there is some sort of a free speech violation to these comments? Like, I just want to know what you think of those actions that employers are taking. And I guess my next double-headed part of it would be, how do you think that this would make people on both sides of the spectrum, especially college kids like us, feel if one is on the left and sees political violence towards the left, and one is on the right and sees political violence on the right on college campuses? How do you think the political ideology of advocating that would, like expressing it, would kind of come out, if that makes sense, like what going forward?
So on the first point, and this is, I think, I'll return to, because I think this has a kinship with an earlier comment about the difference between the law and the spirit of free expression, and developing a culture of free speech. There's certainly nothing unconstitutional, and unless there are states whose laws I'm not familiar with, there's nothing illegal about firing someone. If you're not a government agency, a government institution, or private institution, nothing illegal or unconstitutional about firing someone because they've made comments that you believe are offensive. A government agency firing someone for that reason, I think, raises very serious First Amendment issues, both for me personally and within ordinary First Amendment law. So someone would have a cause of action, I think, against a government employer who fired them for that reason. At least most government employers. Might depend on what your position is. That being said, I think we all have a responsibility as citizens, I'll say citizens lowercase c, whatever your immigration status is, people who are part of the community that formulates the democratic culture of the United States. We all have a responsibility to participate in that culture in ways that allow for the free and equal participation of others. And I think that firing someone because they've made comments that you think are offensive about someone's death, and I tend to be someone who, I have an orientation towards if someone dies, especially if they're murdered in a sort of horrific way, you hit pause on whatever criticisms that you have of them. That doesn't mean you glorify them necessarily, but a period of sort of respect for their families and respect for the fact that they're a human being, like anyone else, I think is appropriate. But if someone doesn't think that's appropriate, it's not for me to say that that they don't get to participate in civil society or something, or don't get to have a job. So I think I think that kind of behavior, especially when you have very, very politically charged situation, I think is not in the spirit of democratic culture. So where are we? I mean, I sort of interpret your second question as, where are we headed? And there, I wish I knew. I think at the moment, it feels like no place good. I think there's a basic talking past each other about just basic ground facts. In fact, I just happened to see this is maybe an example of this. I happened to see a portion of Kash Patel, the FBI director's congressional testimony today, and he was asked about Dylan Roof, who murdered 9 people in South Carolina about a decade ago. And he said, who? Dylan? Who? Who's that? He didn't know who that was. And so if you are in an ecosystem in which you are just, and I'll just assume that he genuinely didn't know. He certainly looked like he didn't know who that was. If you're part of an ecosystem in which you just really don't know basic facts about political violence in the world, maybe I won't speak for Kash Patel himself, but there's a whole bunch of people who really do think that political violence is only happening on the left. There are no doubt a bunch of people who think it's only happening on the right, and don't have any sense of what proportion. This is not a mysterious set of facts, right? There are people who study this who we can say with like pretty good precision, like exactly how much is coming from the right and the left. But not enough of us are sharing, those kinds of basic ground truths. I don't have an answer to what you do about that. I have some kind of vague thoughts, which is to say that part of what I think we really need to, all of us, need to do more of is engage in politics that doesn't have an answer or a conclusion at the end of it. Right? So we have a tendency to structure all of our politics in terms of, we tend to think of politics as fundamentally about who you're going to vote for ultimately. And I think we tend to formulate political issues in terms of, well, which side are you on? Let's debate. We even think about the nature of healthy political discourse in terms of debate. And I think debate can be healthy political discourse, but that's not, I think, the ideal of healthy political discourse. Healthy political discourse doesn't necessarily have an answer at the end. It may very well be just, we're just going to talk through the relevant considerations here. What are the pros and cons? Well, how big are the pros? How big are the cons? More spaces in which we can have those kinds of conversations, which probably have to be convened by people who are not politicians and who are not advocates and who don't have donors, which is tricky, I think would be very helpful. So the more you can think about ways to do that, I think the better.
All right, I'm over here in the middle. Thank you for your talk tonight. We all found it super informative, I'm sure. My question is, you emphasize an autonomy or deference to allow schools to treat speech in an academic lens. Regarding specifically public institutions, this isn't current precedent, however. And so is this attainable?
So I'll sort of interpret that question as, is it even, you've just articulated a vision of free speech that isn't consistent with current First Amendment doctrine. Let's just assume that the median voter on the Supreme Court, Brett Kavanaugh or Amy Coney Barrett, is going to disagree with you. And they're not that old, so they're going to be there for a long time. Is this even attainable or achievable? One thing about people like me, academics, is that we play the long game in the academy, right? So my audience is often students, just as in the 1980s, Antonin Scalia's audience was often students. You communicate with people who are not already predisposed to think in a certain way, and you try to persuade them that you're right about something, and then hopefully not next year, but 20, 30 years from now, the world looks a little bit different, and it looks different in a way that is congenial to the ideas that you think are good ideas, right? So no, Amy Coney Barrett's not going to agree with me. Brett Kavanaugh's not going to agree with me. Neil Gorsuch is really not going to agree with me. But I'm talking to you, not to them.
So when someone like Charlie Kirk, who just passed away, is on a campus who he tend to spread like a negative rhetoric. How would someone, especially someone of color, productively debate with him, in your like opinion or words?
So good. I'm not sure someone can could have productively debated with Charlie Kirk. I think there are, and I say that because I think that and this is why I said to an earlier question, I think the kinds of political conversations that I would want to encourage are conversations that are not structured by people who are professional advocates and provocateurs. He's a political figure. He's a politician. He didn't hold, I'm still saying is, but was. He didn't hold political office. He might have at some point, right? But he didn't hold political office. But he was part of a major political organization, founded and part of a major political organization, was a major part of the conservative political movement. And there obviously are people like that on the left as well. That's content, but that's not discourse. And I think those are different, and I think it's important to understand that those are different. That doesn't mean you don't listen to what people who are producing content have to say, but I'm not sure we get anywhere with, okay, let's get Mehdi Hassan in a room and get Ben Shapiro in a room and have them yell at each other. I don't, that's diversity of political opinion, I guess. But I don't think we get very far. So I think we just need to construct a different kind of politics. That's really hard. It's very hard in the media ecosystem in which we exist. But that's our only hope, I think.
Professor Greene, if I may, over here. So I want to bring us sort of back to the content of your talk, and to you, so what are the distinctions you make between the third and the fourth crisis or panics around free speech? You differentiate them, I think, if I'm understanding this, primarily by the fact that the third one happened on a university campus, and it was university decision to allow or not allow anti-war protests on its campus in the way that they were being conducted, with this expectation that if there are bad actors, how should we deal with that? And for you, that is the jurisdiction of this institution to make that call on whether or not it can allow certain kinds of protest on its space. And then you differentiate that from the fourth one by saying, the fourth one is where the federal government or any political body is getting involved in the process of adjudicating what a university can and cannot do, and that's where you draw the line. It's like, we should allow universities to do that in their autonomous way, but not allow the federal government. The university, in the third example, called the NYPD on its students. And it is hard for me, as an educator, as a professor myself, living in the United States, to imagine a truly autonomous institution of higher education. I would like to believe that there can be one, but history has suggested that the federal government has always tried to influence, and universities have always tried to sort of be in one or the other side of a political sort of alignment. I'm going to be really specific. Do you think Columbia was right to call the NYPD on protesters? Is that an appropriate use of their exercise of what you are describing as their right to control academic freedom on their campus? Thank you.
So I will answer that question, but I want to make a distinction, which is the question is, was it appropriate for Columbia to do it? I want to distinguish between what I think a particular institution, whether I think a particular institution is acting appropriately in the moment, from what I think its legal rights and responsibilities might be. Do I think in deciding about, and there are a number of sort of legal complexities about which forms of law actually bind Columbia or don't bind Columbia. So I'll try to present this as a kind of stylized case, which is does an institution that, let's assume, has some free expression related duties and responsibilities to its students and its other community members, also has anti-discrimination responsibilities to its students and community members, and also has certain duties of fair treatment to its community members that may not necessarily align with anti-discrimination law or free expression law, but they should treat like cases alike and so forth. Should they have the kind of legal discretion to have that decision not interfered with? I think in the main, yes, they should have that discretion. There's always marginal cases, but I think in the main, yes. Was Columbia right to call the NYPD on its students? Well, Columbia has called the NYPD on its students in the course of Gaza-related, BDS-related protests, if I'm not mistaken, 3 times in the last 2 years. I don't remember when we are in time anymore. A year and a half, let's say. The last year and a half, 3 times. The first of those instances was to clear encampments from the south lawn of the main campus, Morningside Heights campus. The second time was to clear students out of a building they were occupying, an administrative building they were occupying. The third time was to clear them out of Butler Library. And I'll just say that Butler Library is the main undergraduate library on campus. For 2 of those instances, I was not at Columbia. I was working in the federal government, and so I don't have a great intimacy with all of the relevant considerations. I thought it was, and the faculty senate unanimously thought it was reckless for Columbia's president to call in the NYPD in the first instance to clear encampments. There are ways of dealing with, so the encampments violated the rules of student conduct at Columbia. Students violate the rules of student conduct on university campuses all the time. And as an administrator, your job isn't just to punish them, right? Your job is to educate them in part, right? So that requires some discretion, it requires some leeway. Columbia University has a very long and not very distinguished history with the NYPD, and one has to be aware of the expressive value or expressive lack of value, whatever the opposite of that is, expressive harm of calling at the NYPD onto campus. And I think that's not a decision you make until, in light of the totality of the circumstances, you think it's absolutely necessary to do that. I think that clearly wasn't the case in the first instance. And that decision was made from a conference room in Washington, D.C. by the university president. The president should have been on campus. It's just totally wrong decision, in my view. The second 2, I think, are much harder because the second 2 involve occupation of a building. In one instance, it involved, at least briefly, university employees being detained by people who had occupied a building. There were interruptions with the ability of other students, faculty, administrators to attend the university when you occupy a library, the main undergraduate library. So, and if I'm not mistaken, this was close to or during finals. That I think is a disruption to the life of the campus. And if you're not able to, again, you don't call the NYPD onto your campus unless you have to. If you're not able to handle that situation with your own security and with your own interventions and diplomacy, then I don't, again, based on the information I have, I don't fault them for calling NYPD, especially if, as happened, if they're not going to press charges against the students, right? So the students don't have arrest records. They're expunged. They're based on, at least most of them. There may be some exceptions, but by and large, this is not something that causes a criminal justice record to be produced. It's really a mode of controlling the space on your campus. So I think, again, I think those situations are different. We're also much further along in the conflict between the administration and its students in the second and third instance. And so there's more information that everyone has about exactly what the rules are. And I think the first time around, again, when you have protests on campus, when you have a set of rules and those rules are never really followed, disciplining students in a particular way for pushing the limits or engaging in acts of civil disobedience, I think is particularly problematic. I think once you're further along and everyone sort of understands, here are the rules, here's what the consequences are going to be. You can decide to engage in civil disobedience. You're going to get your zip ties. You're going to go down to one police plaza. If you push it past this point, I think that's more defensible.
Hello. When you were talking about the 1,000 blossoms or 1,000 flowers blooming analogy, that kind of brought to mind a personal experience I had, specifically at my high school, where there was a prevalent rise of an alt-right movement, specifically with Turning Point USA, and I saw firsthand what I would think is a trend among, especially as one modern young men living in the country, which are these controversial ideas being excluded from mainstream discourse. So those ideas or those people then go and find their little, or find some sort of cave or echo chamber to find solace there, and then they re-emerge much more radicalized and much more reactionary. And this has come about as what I see as a movement to democratize debate, not have it just on stages with people sitting in chairs drinking glasses of water and talking about their own opinions. But what I've seen specifically with Kirk's movement is after this democratization of discourse, such as on social media or college campuses, there's been a big rise in that sort of alt-right radicalization, which frightens me. But at the same time, I have to think about what you said about the 1,000 blossoms blooming. We need all these ideas, but I think when it comes to radicalization, I find that objectively bad. So my question is, from your perspective, is there a legal or social approach that can realistically, if at all, prevent this cycle of radicalization among the youth?
So great. Let me say a couple of things in response to that. So one is, when I say that there is a value in letting 1,000 flowers bloom, I don't quite mean that in the sense of as many. I'm going to make a reference to kind of free speech theory, right? The marketplace of ideas, right? You just let ideas proliferate in the free market of ideas, and if you do that, the best ideas will be the ones that flower. And I think that presumes, just as in economic markets, financial markets, there are market distortions everywhere. There are market distortions in the market for free expression as well, and there is literally no reason to think that if you let all ideas proliferate, the best ideas are going to be the ones that are best promoted. That doesn't mean that you should legally regulate or arrest people for having certain ideas. There are other reasons why you should not necessarily have a heavy-handed approach to ideas that you think are wrong or offensive or disfavored. But the theory on which I believe one should tolerate ideas that one thinks are profoundly wrong is not a theory that is not a 1,000 flowers bloom theory. It's a different theory. When I said let 1,000 flowers bloom, I meant more in terms of thinking about different regulatory approaches to race-based harassment, for example, or and so this actually speaks, I think, directly to your question, which is how do you respond? And you said, well, if you suppress certain kinds of speech, that leads it to be siloed and it develops its own kind of internal ecosystem, and that can be problematic. And suddenly, there's a whole, violent movement that you didn't even know about or that felt alienated from popular discourse or what have you. But on the other hand, if you don't regulate it, then you're normalizing it, and that can lead to its own set of problems. That's a hard problem. How do we solve hard problems? Well, one of the theories of federalism is that one of the ways you solve hard problems is you articulate the problem, and then you create a lot of problem solvers. And then you see what works and what doesn't work. And then you have data, and then you take that data and you use it to try to make progress on solving the problem. So we can learn about how to make it less likely that people who are alienated from society develop destructive and violent ideas. I would not presume to be able to stand at the podium and tell you what the answer is, but I do have a certain faith that we're able to learn more about how to solve these kinds of problems. And so that is the benefit of letting 1,000 flowers bloom, and at least the metaphor that I'm using is to say we need data. And it is, I think, hubris, and that's part of my concern, is that it's hubris for the federal government, whether it's Donald Trump or Joe Biden or a federal judge, to say, no, the Constitution tells us exactly what to do with this problem. It doesn't tell us what to do with this problem. It tells us what we should think is valuable. We should think free speech is valuable, and it is. But it doesn't tell us exactly what to do with that when you've got very serious social problems.
Do you see any sort of connection between the attack on academic freedom and expertise, particularly related to the cutting of university research funding? Do you see a relationship between that and sort of the defense of free speech, and particularly thinking of like the second panic in regards to the Columbia talks that were given on immigration, not by immigration experts, but rather sort of provocateurs, and that like we are defending the rights of sort of people who like are not knowledgeable on topics. Like we're defending their right to participate in the debate while sort of undermining the like actual experts' rights to participate or like conduct research in those areas.
I think yes, and I think this does connect to the democratization of speech that the last question was about. And I think there is and by the way, I do think Mike Cernovich or whoever, I do think they have a right to participate in immigration debates. I don't think they have a right to do it on Columbia's campus if Columbia doesn't want them there, right? So that's the difference. And now Columbia is a private institution, but I'd say the same thing about a public university. And I think that our inability to make that kind of distinction relates to exactly the kind of problem I'm talking about in terms of not understanding different institutional contexts. I think the Supreme Court has encouraged a kind of flattening of the discourse that then acts in harmony with certain pressures in social media and the democratization of access to voices and to audiences. And I think this has kind of worked together to produce a kind of And thank you all for the great questions. They were really very incisive.